gather together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations, and grant that we, having affairs before our eyes, and laying aside all private interests, prejudices, and partial affections, the results of all our counsel may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This Honourable Senate now resumes its sittings. It was my intention to bring to the attention of the Honourable Senate the fact that the Bar Association of Jamaica is honouring 3 stalwarts of the Jamaican legal profession, former Chief Justice McCullough and Queen's Counsel K.D. Knight and Dorothy Lightburn. But since Senator Knight is not here, I'm going to defer the tributes which I know that you are rearing to pay to our colleagues, Dorothy and Katie. So we'll do that at some future point, but please just make a note that I have brought it to your attention. And I'll be sitting at your table later, Motley. Statements by ministers. Announcements. Thank you, Ms. Curtis. Our clerk, Mrs. Cook, is still having a vocal issue.
All right. Laid on the table of the Senate today are the following: Ministry Paper number 67 of 2018, an annual report of the Betting, Gaming and Lotteries Commission for the year ending March 31, 2016. Ministry Paper number 68 of 2018, entitled Solving Global Tourism Challenges through the Global Tourism Resilience and Crisis Management Center. Ministry Paper number 69 of 2018, an annual report on financial statements of the Coconut Industry Board for the year ending December 31, 2016. Annual report on audited financial statement of the Jamaica Urban Transit Company Limited for the year 2015-2016. The Toll Roads Technical Designs, Operations and Maintenance Standards Regulations 2018, and the Toll Roads Technical Design, Operations and Maintenance Standards Regulation Resolution 2018, and the Toll Road Registered Regulations 2018, and the Toll Roads Registered Regulations Resolution 2018 under the Toll Roads Act.
Thank you, Ms. Curtis. Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 30th day of July 2018, the House of Representatives agreed to the Senate amendments to the bill entitled An Act to Amend the Public Procurement Act. I also have the honour to advise the Honourable Senate that on the 10th day of July 2018, the House of Representatives agreed to the Senate amendments to the bill entitled An Act to Provide for the Establishment of an Agency of Government to be known as the Major Organized Crime and Anti-Corruption Agency to investigate and prosecute serious crime and matters related thereto. I have the honor to further advise you that on the 10th day of July 2018, the following bills were passed in the House of Representatives. A bill entitled An Act to Repeal the Fishery Industries Act to provide for the efficient and effective management and sustainable development of fisheries, aquaculture, and other related activities in accordance with internationally recognized norms, standards, and best practices, and to provide for matters connected therewith and incidental thereto, was passed with 2 amendments, and a bill entitled An Act to Give Effect to the Provisions of the International Convention for the Control and Management of Ships, Ballast Water, and Sediments 2014, was passed with 2 amendments.
Mr. President, I signify my willingness to take charge of the 2 last mentioned bills.
Excuse me. A bill shortly entitled the Fisheries Act 2018, read the first time, and a bill shortly entitled the Ballast Water Management Act 2018, read the first time.
Mr. President, I beg to give notice of second reading.
Thank you. Petitions, papers, reports from committees, notices of motions given orally.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following 2 motions. The Toll Roads Act, the Toll Roads Registers Regulations Resolution 2018, whereas by virtue of Section 32, subsection 1 of the Toll Roads Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations for giving effect to the provisions and purposes of this Act. And whereas by virtue of Section 32(2) of the Act, the regulations made under subsection 1 shall be subject to affirmative resolution. And whereas it is desirable that the Toll Roads Registers Regulations 2018 be affirmed, now therefore be it resolved by this Honourable Senate as follows. 1. This resolution may be cited as the Toll Roads Registers Regulations Resolution 2018, and 2. The Toll Roads Registers Regulations 2018, which were laid on the table of the Senate on the 13th day of July 2018, are hereby affirmed. And the Toll Roads Technical Designs, Operations and Maintenance Standards Regulations Resolution 2018, which reads as follows. Whereas, by virtue of Section 32, subsection 1 of the Toll Roads Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations for giving effect to the provisions and purposes of this Act. And whereas, by virtue of Section 32, subsection 2 of the Act, the regulations made under subsection 1 shall be subject to affirmative resolution. And whereas it is desirable that the Toll Roads Technical Designs, Operations and Maintenance Standards Regulations 2018 be affirmed, now therefore be it resolved by this Honourable Senate as follows. 1. This resolution may be cited as the Toll Roads Technical Designs, Operations and Maintenance Standards Regulations Resolution 2018. And 2. The Toll Roads Technical Designs, Operations and Maintenance Standards Regulations 2018, which were laid on the table of the Senate on the 13th day of July 2018, are hereby affirmed.
Thank you, my lady. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business. Minister.
Thank you, Mr. President. May I inquire, Mr. President, now that the circumstances that you referred to earlier have changed, whether you intend to take that matter now or whether you wish to? All right. Thank you, Mr. President. It is intended today, Mr. President, to continue the debate on the child diversion bill and to take it through its remaining stages. Thereafter, it is proposed to deal with the matters at numbers 3, 4, and 5 of the order paper. That is the resolution in relation to procurement regulations, the 2 procurement regulations which were, notice of which was given last week, and the mutual criminal assistance, sorry, I keep saying mutual legal assistance, notice of which I gave the preceding week. In that context, I believe the opposition was next to speak on the child diversion bill. Do you wish to start?
Minister, the record indicates that Senator Reid introduced the bill. Senator Crawford spoke, then Senator Webby. So I think it's Senator Fraser-Binns. Senator Fraser-Binns, thank you.
Thank you, Mr. President. Thank you. Mr. President, I wish to make some brief remarks on this bill entitled the Child Diversion Act. Let me just state, and I think the minister mentioned it in his opening, that in fact this bill originated under the previous administration. And I don't think, Minister, that you commended then Minister of Justice Golden. And I think that the record should commend him for the efforts and the work that had gone into. But we also want to commend you, Minister, and of course, Minister Chuck, for continuing what I believe is something that will transform all our children's lives, particularly children who come in conflict with the law. Mr. President, this bill is very timely and really could not come at a better time. I want to share some statistics with you. Between 2012 and 2013, over 479 children were said to be perpetrators or in conflict with the law. Between 2013 and 2014, this number increased to 565, with the main offense being sexual intercourse with a minor, break-ins, rape, and aggravated assault. Between 2013 and 2014, there was a marginal reduction, and there were 460 male that were transferred to the Metcalfe Street Juvenile Remand Center. And it is also timely because last week there was an article in the papers, but I also got some information by way of a video that I was forced to watch. And having watched it and having listened to the stories of these children who have been placed in the care of the state, I really shudder to think that this was someone's reality. And so I am so very pleased, Minister Reid, that today we're taking a different approach. We're taking a progressive approach to how we treat with our children who come in conflict with the law. There is overwhelming evidence, and you mentioned that children who generally have to interface with the court or the justice system hardly ever end up with a positive result. In fact, I was doing some reading and looking at the figures in the US, and it showed that there was a very high probability that children who interface with the criminal justice system end up being perpetrators themselves or recommitting an offense. But more so, what is clear is that children who tend to come in conflict with the law are generally from a particular socioeconomic background. And a 2011 study by the OCA reveals that of the group of boys that were in conflict with the law, they were usually poor readers, they were from low socioeconomic background, Some of them did not know their father. If they knew their father, they lived with their mother, and there was no role model in their lives. And so I am pleased that one of the things that we're trying to do here is not only to keep our children away from the court system and away from the criminal system, but also to offer that kind of psychosocial support which so many of our children need. And this is a positive step, because when one looks at the outcome of these matters and the intervention like what is being proposed here, what you find is that there's a gradual reduction in the number of children that are placed in the care of the state. And it also allows children to rehabilitate in a familiar environment. And clearly, Minister, it is less costly. And so there is absolutely no doubt that what we're doing is good for Jamaica, is good for our children, and is good for the future of our country. Now, this bill, Mr. President, touches my heart, because I remember an experience I had when I was at OCA. And as you're aware, part of what we do at the Children's Advocate is to offer legal representation to children who come in conflict with the law, who are unable to afford legal aid. And I remember talking with a 16-year-old child, and from all information available, he was a generally well-behaved child. He did well in school, but he was brought before the court on a sexual offense. And I tried to understand why he did what he did. And you know, he said to me that he knew the age of consent was 16, and he genuinely thought that the young lady, who was his girlfriend for a few years, was 16. But the moment he found out that she was not 16, he broke it off. And he said during that period, she would literally taunt him. Her friends would come and taunt him. But he said what led him to doing the act that got him into trouble was one night he received a text from her. And essentially it said that if she did not get a chance to be with him, she was going to die. And he said, in his own childlike mind, he felt he did not have an option, and so he obliged. And the parents, they were caught, and he was brought before the court. And a system like what is being proposed today will help individuals like that youngster, so that he's not brought into the criminal system, but also he's given this kind of support he wants, so that the next time he's faced with such a situation, he'll be stronger and he will know how to treat with it. And that being said, I now want to make some comments specific to the bill. And Minister, as I said, I fully support, and my comments should be seen as enhancing the bill. So I want to start by looking at Clause 2. And the definition of child offender. It defines a child, page 2, Clause 2. It defines the child offender as a child who is suspected of, accused of, charged, or convicted of a diversion offense. And then it goes on and it defines conflict with the law, meaning conflict law in relation to a child means taken into the custody for constable on suspicion of having committed a diversion offense or detained or charged with a diversion offense. I brought it up because I noticed, and if you go to Clause 9, line 1, on page 12, you will note that there's reference to a convicted child. But on the reading of the definition of conflict with the law, it does not include a child who is convicted. But also, which is perhaps more important, when you look at the definition of, Section 3, I'll come back to that. Then it does not include. So I wanted to find out from you, Minister, whether the intent, which I believe it is to include a child who has actually been convicted, as opposed to one who has been arrested, charged, or who's likely to commit an offense. I just wanted some clarification on that.
Trying to follow what you're saying about the definition. You could just assist me again? Okay. Tell me again.
So, Clause 2 defines a child offender as a child who is suspected of, accused of, charged or convicted of a diversion offense. But when you look further at the definition of conflict, a child who is in conflict with the law, it does not include a child who has been convicted. And so I wondered whether that was intentional or whether it should be expanded to include a child who has been convicted. And that is borne out when you look, for example, Mr. President, at subsection 3. That is correct. And when you look, for example, at subsection 3 on page 5, it does not, subsection 3, Minister, speaks to how the act should be administered and interpreted. And it does not include a child who has been convicted. So I think for certainty, we just need to be sure whether it is intended to include a child that has been convicted. I am thinking that the aim of the act is not just for children who have been charged, but children who have been convicted. And you see that when you go through, I mean, the amendments to the Parole Act, for example, speaks to it. So I think we just need to be clear. At Clause 7, Clause 7 establishes the functions of the Child Diversion Committee. And Minister, I need some clarification on this, because when one looks at all that this parish committee is being asked to do, I wondered whether they're going to be full-time or part-time employee, or whether they're going to operate as a board normally operates. When you look at, for example, that they're supposed to conduct research, studies, evaluations, and other studies, and that is at 7.1f. 7.1h talks about formulating and recommending policies and strategies for the prevention of child delinquency. And 7.1j talks about furnishing the diversion office with such reports. It seems to me that this ought to be a full-time job, but when you look at the persons who comprise the parish committee, it seems to me that they're really volunteers who may just get a stipend like regular board members. And I would hope that given the important role that this program will play, that some thought will be given as to how it is operationalized, as to the amount of resources that will be allocated and the personnel. And when you go to the second schedule, there is no provision there for them to employ. They can engage persons by way of establishing subcommittees, but there's no provision there for them to employ persons to undertake these tasks. So I shall like to have a better understanding from you, Minister, as to how you envision these parish committees working. Still at Clause 7, looking at 1J, sorry, 1I, I'm sorry, that says that the parish committee will nominate a member of the committee to attend meetings of the National Child Diversion Oversight Committee as required by the PS. I do have a little discomfort with that, Minister, because I don't think that it should be a decision that is left to the permanent secretary. Yes, she is a principal accounting officer in the ministry, but if you have parish diversion committee, then my thinking is that the best practice would be for a representative from each parish diversion committee sit on the National Oversight Committee for continuity and for maximum sharing of information, notwithstanding that the Parish Diversion Committee will report to the Diversion Office in the Ministry of Justice. So I would want you to give some thought to that in terms of us ensuring that a representative from the Parish Diversion Committee sits on the National Oversight Committee. Clause 8. And Clause 8 says that the minister may establish a national committee. It may seem like a small point, Minister, but I don't think it should be may. It should not be discretionary. I think the minister shall. It should be mandatory that the minister establishes this national committee. And for reasons I mentioned earlier. Yes, that's a good point. If not the national, if the minister decides not to set up the National Oversight Committee, then is there something that he will do instead? So I crave further thought on that, sir. Looking at 8.2, subsection 2. Subsection 2 provides that the child can only be referred to the program if the victim consents. Now, I have a problem with that. And it is not that you're discounting the experience and the reality of the victim, because you have to bear that in mind. But it should not be, a child being placed in the child diversion program should not be dependent upon the victim agreeing. And so I ask, therefore, that further thought be given to that. And I can understand the thinking, Senator Reid, because throughout the Act, and when you look at the initial documents, you see that this child diversion program is part of the general restorative justice. And in restorative justice, we want both parties to agree and, work through finding an amicable resolution. But given the very nature of this program, we can't clothe it in the complete fabric of restorative justice. There has to be.
I looked at that and I agree with you. Perhaps some notes, for example, if you say rather than an agreement that the victim or whatever it is be notified in writing or something.
Absolutely. Thank you, President. We are agreed.
You want to help a child, to save a child. Whether the victim or not, the victim might stand to malicious as a no. As a no, sir. But you want to save a child.
At Clause 9, Minister establishes the standard for a child to be diverted. In Clause 9.1, it references, there is reference to children who are charged with diversion offenses and children who are convicted of diversion offenses. Clause 2 then goes on and lists 4 criteria. The child offender should accept responsibility. There's a prima facie case, the victim consents, and the consent of the accused. I also have a challenge with that because we should not conflate. I think we need to separate in this situation where you have children who already convicted and those who have been charged or those who have been warned or those who have been cautioned and are now going through the program. I think you need, because the treatment, the criteria as established does not apply to both categories. And so you need to delineate the categories and provide the criteria accordingly. Are you following, Minister? Yeah? Okay. And it makes sense because why, if a child has already been convicted, why would you need, for example, a consent of the victim? So it just makes sense that you delineate that. If we can go to page 17 and clause 15. When one reads the preceding provisions from clause 4, you get the distinct impression that the intent is that the Child Diversion Office would design a program specific to the child. I want to believe that is the intent, that my understanding is correct. And if my understanding is correct, then I am at odds with provisions in clause 15, for example, 15G, that speaks about the program should be capable of being administered in various locations, circumstances, and for a number of diversion offenses. Each case in my mind will be considered based on its own peculiar facts and circumstances. And so the program that is designed for that child may differ in substance from any other offense. And as such, each program should be designed specific to the child without any consideration of how it is applicable to any other child. And Minister, I see you raise a head, but it makes sense. If we're going to maximize the objective, then no, what it says for a number of diversion offenses. And let us go at I. I says that the program must be developed to take into account the needs of children in rural areas or remote areas in the parish. And I want to change that a little to say to consider the locale or the location or the geographical implications of geographical environment. Because, you know, even though I'm a country girl and I always celebrate my country roots, the fact is that children in Kingston, in urban cities, in urban centers, have very specific issues that ought to be considered, Minister Reid, when this program is being designed. So I am proposing, therefore, that we take a second look at this and we can just reword it so that it considers that which you want to achieve without limiting it to rural parishes or remote areas in the parish. Because it means, like, for example, a child that lives in Fletcher's Land. Fletcher's Land is in no way remote. But that child, that would not be considered in designing the program for that child because Fletcher's Land is at the heart of an urban city. Yeah? No, but look at what 15I is saying. Vulnerable communities? But you have vulnerable communities in urban centers. All right, so you will have an opportunity in committee and we can explain further. Correct. All right. Clause 19. Clause 19 deals with the failure to comply with or complete child diversion program. And essentially, what it says is that where a child refuses or fails to complete the program, then it gives the option or the discretion to the constable to charge the child and bring the child before the court. Or if the child was before the court and the matter was suspended or adjourned, then the matter reverts to court. Specific to the child who was placed in the diversion program by the constable, I would want us to consider an amendment to 19.1, which allows the constable to determine the reason for the failure to complete, rather than bringing the child to the court for the court to make that determination. And I say that because we want to go back to the overriding objective, which is to keep our children out of the court system. And if a child fails to complete the program, there could be many reasons, some reasonable, some may not be reasonable. But I believe that on the reading of Clause 19, that power is not given to well, it's not expressly stated that the constable has that authority to make that determination. (19.1). That is one of the many things that we're trying to avoid. So that would be a concern. That's what we're trying to avoid. There may be some situations, Minister, where the child will have to, if the constable determines that the child has just refused without more to complete, then he may have no choice but to charge and bring the child before the court. There are going to be situations where that must be done, but I'm saying it should not be the first act. So the child fails to complete, let us investigate, determine why, and then. All right. Clause 20. At clause 20, which deals with the minister having certain powers, it says that the minister may prescribe, and at subsection 2, for the purposes of this act, the minister may approve in writing suitably qualified counselors and psychologists in respect of each parish. I want to find out from you, Minister Reid, why is that power given to the minister? (22). But that doesn't mean that we have to be tied to the education regulations. But you can respond if there is a good and compelling reason. I can be convinced. Let us look at warnings, cautions at clause 21. And in this provision between 21 and 23, it gives the minister, it gives the constable power to do one of three things: to either issue an informal warning, a formal warning, or to do a caution, to issue a caution. I am not convinced, Minister Reid, that in terms of an informal warning, the conditions are clearly stated. That is, from my reading of the bill, I do not see where it lists the conditions or the considerations to which the constable must address his mind in making a determination to give a child an informal warning. And I also wanted to find out from you whether it is the intent that an informal warning can be given at any place compared to a formal warning which specifically has to be done at the police station. And if you look at clause 33, for example, on page 30, it outlines, and I'm just giving this by way of comparison, because it outlines the things that the court may consider. That's 33.3. It outlines the consideration that the court may address its mind to when making a determination to issue warnings. And I thought that perhaps that is something that could be applied to the police constable when he's making his determination to give a formal or informal warning. I have no challenge with the conditions as established for the caution, but for the formal and informal, I think we just need to look some more at that. At clause 25, clause 25 deals with the matter I mentioned earlier in terms of the locale or the location for an informal warning as opposed to a formal. The formal warning has to be done at the police station as per the clause, but there's no provision in terms of where the informal warning should take place. So if it is the intent that it can be done anywhere, that's fine, but I just think we need to be clear. I spoke earlier about the need for, or the fact that I don't think it is necessary to have the consent of the victim, and Clause 28 also deals with the requirement for consent, and I ask that we take a second look at that. And it does not, the fact that you may agree, Minister, that the victim doesn't need to consent, does not take away the right or the opportunity of the victim to participate in the process. Because if you look at the provisions in Clause 16, then there is an opportunity for the victim to get involved, to give her his or her views, and to make recommendations. I want us to look at the second schedule. And I have a little unease, and perhaps, Minister, in your closing, you could help me here. But second schedule looks at the amendments to the child, the second schedule, 1 minute. The Child Care and Protection Act. Maybe it's not the second schedule. Just give a minute. It's the fourth schedule. And I note the proposed amendment to Section 24 of the Child Care and Protection Act. And I wondered whether we ought to be amending the Act, that section, or we should dispose of Section 24 in its entirety, or rework Section 24 to include the amendments. My first option is to really repeal that section. And this is so because you are aware that it is the International Convention on Civil and Political Rights. It is in contravention to that convention. Page 55.
Senator, you're wrapping up or you have some time to go?
I still have a few more minutes.
Okay, thank you very much. The Speaker's time has expired. Madam.
Mr. President, the Speaker's time having expired, might she be granted another 15 minutes? So to complete her presentation, thank you.
The question is that the Speaker be given sufficient time to complete her presentation. Her time, allotted time having expired. In favor?
No, man, it's fine.
Against? Senator Fraser-Mintz.
Thank you, Minister. Thank you, Mr. President. So what I'm saying, Minister Reid, is that Section 24 of the Child Care and Protection Act deals with children who, essentially parents having the right to take their children to court because they're deemed to be uncontrollable. And in light of what we want to accomplish, notwithstanding the amendment here, I am proposing that when one considers that it has been said that this section is in breach of international convention, whether the best approach would not be for us to repeal that section. Stand by Jamaica. So that's the point I want to make. And having highlighted those sections, Minister, I have some questions for which I am hopeful that you'll provide some answers. And I'm wrapping up. I did not see in the Act, apart from the requirement for the victim to consent, and apart from some provision for the victim to be consulted in terms of the program and making payments, I do not see anything in the Act that deals with any treatment for the victim. And I know that the principal objective is for the child who is in conflict, but similar to the child who is in conflict and the desire to provide some kind of psychosocial treatment, I think that there ought to be some provision, perhaps not in this Act, but there ought to be some provision for the victim. And I mentioned earlier the issue of resources, and I want to know, Minister, how will this project be funded? When one looks at all that is being required under this bill, all the personnel that has to be engaged, there is a need for additional personnel. You know, yesterday I had a discussion with a probation officer, and she was just lamenting the fact that she alone has 65 cases that they have to visit all the courts in Kingston and St. Andrew, all the courts, and that there were only 13 officers in the office. And the work of the corrections or the probation officer is not going to be is not very different from what is anticipated will be the job of the personnel who will have to interface with these children. And it is going to be critical that sufficient resources, human and otherwise, are provided to ensure that the objective can be achieved. And also, I wish to know, Minister, because the Act turns on one thing, as an accused, you can only participate in this program if you, for want of a better term, plead guilty. What happens to a child who is innocent? There's no consideration, no provision. That child, if that child is genuinely innocent, the child was not committed, the child has been framed, whatever, there's no provision, no consideration for that child. That child, because that child is innocent and maintains his or her innocence, will have to subject himself to the court process and the juvenile court process. So at some point, we need to give some consideration about how we treat children like that, and that we are not creating a situation that incentivizes persons to plead guilty just because they don't want to go through the court process, but because it is easier to be referred to the child diversion program. And with those very few remarks, Mr. President, let me just say that I really do support this bill, and my comments are really aimed at strengthening the bill so that we can achieve our objective. Thank you, Mr. President.
Thank you, Senator Fraser-Binns. Minister? Oh, I'm sorry.
Thank you.
Senator Charles Sinclair.
Thank you, Mr. President. Mr. President, as has been said by all speakers before, I do support this bill entitled Child Diversion Act 2018. And Mr. President, and having heard the comments from the other side, that they do support it, although they have made their comments, and I'll address a couple of those. But this bill, Mr. President, has been through a series of consultations prior to coming to Parliament, and the whole discussion of child diversion. And I heard a comment from my friend, Senator Fraser-Binns, who spoke to the work, pardon me? Who spoke to the work done by Senator Golding. And I will just take her back a bit before that to the contribution made to this whole discussion of child diversion. And it was reported by the GIS, November 18, 2010, that the discussion and the development of the child diversion policy under the efforts of the Ministry of Justice. The minister at the time was Senator Dorothy Lightburn. And this initiative is just was part of the National Plan of Action on child justice. Yes, and I'm saying that the discussion in relation to where we are today comments from that point in time. So the commendation must be given to the effort to the effort of all persons who would have started this entire process leading up to this point in time. And so it has been through significant consultation. Mr. President, Jamaica is also a signatory to the various United Nations conventions on the rights of the child. And the passage of this bill will indicate our commitment to the implementation of measures which ensure that children in conflict with the law are treated in a manner that upholds human dignity and worth and avoid them from the deleterious and stigmatizing effects on the child of criminal conviction and detention in correctional facilities. And we have been dealing with legislation that deals with children over a period of time: the Juveniles Act, the Child Care and Protection Act, the Restorative Justice Act, to name a few, and in respect to the special guidelines that has been implemented in relation to sentencing of children involved in criminal matters. But, you know, from a personal point of view, Mr. President, and in spite of the good efforts of the persons who have had responsibility, I visited in St. James the areas where children are detained when they come in conflict with the law. For the males at Barrettown, so they are separated from the adults. You have a special area where they are kept. But those areas, the females at Cambridge. But on a visit that I made to those police stations, Mr. President, as a male, tears almost came to my eyes to see the condition in which our children who may find themselves in conflict and who may be innocent, they are presumed innocent, but they find themselves in very difficult circumstances. A small holding area, there is no appropriate area for them to even rest their heads. So when we consider what this bill is seeking to achieve, to keep them out of a system like that, it is very commendable. And there are certain aspects which I wish to make reference to of note in this bill. And
don't talk about the fact that some of them are brought into town to Metcalf Street out of the range of their family.
And yes, Mr. President, and the movement, if they have to go back to areas that are far away. And Mr. President, the emphasis on reform and rehabilitation through the child diversion program, and which a child must participate in, is commendable, and clauses 14 to 16 speak to that and establishes a program which, one, is certain because it is in writing, is structured, monitored, flexible, and can be tailored to the specific needs of the child and the community, and is available at a location that is convenient and accessible. Very commendable aspect of the bill. The process of inclusiveness, where the victim also has a voice, the community has a voice, which will go a far way in the smooth reintegration of the offender in society. I just wish to highlight that as another commendable aspect of this bill. And the program, Mr. President, encourages responsible behavior on the part of an offender, as it may include orders for the offender to give service to the community or to make appropriate amends to a victim, which may not necessarily include monetary compensation. And the bill allows for administrators to be creative and innovative in crafting the appropriate program to fit the particular situation and the particular child. But in the implementation of this bill, Mr. President, we have to really sensitize our country, the citizens of Jamaica, and reorient their minds, because many Jamaicans have been cultured on the principle of an eye for an eye. And what we need to change that to divert that to, is that we must turn the other cheek. Yeah, well, there you go, there you go. Mr. President, great effort and the resources has been spoken about by Senator Fraser Binns must be found and the involvement of all stakeholders must be mobilized. Community-based organizations can be checked to see who can accommodate programs of this kind within the community. And I must speak of the community that I provide representation at the local government level, which has the Flanker Resource Center, which is a center which is multifaceted, and it is already staffed. It has computers there, it has a library, and presently they are taking persons who have been suspended from school in order to seek to place them along the correct path. And in fact, under Zozo, in the Mount Salem area, presently opened in April, the Parent Resource Center is another community-based location where I can see this particular program under the Child Diversion Act fitting in quite nicely. But where I have a concern, and I think Senator Crawford had spoken to it, is that this bill really addresses the back end of the situation. And we would want to have is not that when they get in conflict that they are diverted, but they can be prevented from getting there in the first place. And Mr. President, the comments by Senator Crawford, apparently he did not look on the other aspects of what exists through agencies and through programs. And I would just highlight briefly a few of those, the dispute resolution opportunities that exist. Agencies such as the Child Development Agency, which can capture young persons prior to them finding themselves within the system. The Children's Advocate and the Children's Registry that exist. The whole program, Mr. President, is also an important program which seeks to intervene and provide alternatives for youths before they find themselves in conflict with the law. So there are several programs. I can mention others. School Leavers Training Opportunities Program is also very important. And what Senator Crawford apparently did not look at when he was addressing the whole issue of youth and giving them a second opportunity is a particular legislation which in its present state, I think needs a little adjustment because of an amendment which was made in 2014, Senator Knight, which seeks to take away a second chance for many persons in our society, and that is the Criminal Records Rehabilitation of Offenders Act. Because there was created in 2014, Mr. President, a third schedule, which has prevented some persons from being able to apply for expungement of a criminal record, which they may have obtained out of youthful exuberance, if one could use that word. So, you know, I expected that after it came out. I expected that from you. I expected that from you, Senator Knight. But you understand. I'm happy to hear that, sir. So, and I'm certain you will support that position. Although it was an amendment which was made whilst you sat in this particular Senate. Yes. So, Mr. President, what we have to look at is to deal with situations prior to children getting into conflict in a holistic way and to try and avoid them getting into conflict that will require the application of this particular legislation. And I'm happy to be a part of this administration which recognizes that and in which we have implemented the National Service Corps, which just recently, Mr. President, graduated at Monegin Center on June 9, 2018, 232 young men. It has engaged young people in a positive way, providing them with critical tools where they can become better citizens, affording them an opportunity to become skilled and socialize in maintaining law and promoting peace. Mr. President, just recently at the CARICOM heads of government meeting, some of those young men who fitted into that program participated and did us proud at the opening ceremony of the CARICOM heads of government. Mr. President, the community renewal program is also one aspect of that this administration is looking at, and it is being done in collaboration with GSIF, where over 20 of the most volatile communities across the island are being targeted and to engage the youth in productive and legal enterprise. And, you know, under even the ZOZO, the improvement of communities, the physical appearance of communities, the amenities within communities, I'm certain will go a far way in changing the psyche of those who live within them, including our young people. And the GSIF program in the Mount Salem area is off to a good start. There have been significant improvements, the removal of zinc fence, improvement of roadways, and other things taking place under the ZOZO, and I am certain that it is going to augur well. It is going to augur well. I have not diverted. What we need to do is to ensure that they don't get into where they require the formal type of diversion. Mr. President, parenting skills to prevent our kids getting into situations that require the Diversion Act to be used. Mr. President, the reality of it, you know, is that not every human that should bear children or contribute to the birth of a child should have children. That is just my opinion. It's, well, you know, Mr. President, I was looking at Mr. President, I saw published in our daily, I saw published in our daily, you know, sometimes
Senator Sinclair, just address me and continue, please. Thank you.
Just recently, there was a report in our daily newspaper.
Senator Scarfrey, when you're making your contribution, you can raise it, please.
A report on reproductive health survey, which was conducted in 2008, which states that just under 50% of live births in Jamaica were unintended. That is what came out from a survey which was done and which was recently reported on. Mr. President, many of our children have been forced into state homes and into foster homes, not because of the death of parents, but because parents have just been unable to manage socially or economically. And so what we're speaking about what we need to speak about is to improve the responsible action of our adults. The report by Dr. Thorburn, and I believe you made mention of it, Senator Fraser-Beans, Jamaicans for Justice, reveals horrific stories. And that is where we have found ourselves because of what I describe as irresponsible behavior on the part of some of our adults. And you know, Mr. President, one has to look on the whole issue of parenting. And as was disclosed by a former children's advocate, Mary Clark, in 2006, and I'll quote from her, the impact of improper parenting or lack of parenting is evident today. We hear of teenage pregnancy, indiscipline, school violence, and other forms of antisocial behavior. Ever so often, we can trace these back to the home and the type of guidance and values and attitudes that are being imparted to children in the home by parents or guardians. Parents must be provided with adequate knowledge, services, and skills on child development stages, child rearing, discipline, and how to guide their children. We have to provide the help that the parents need. Mr. President, the answer to this must be the provision of adequate services for counseling of persons and have them accessible and community-based. Educational opportunities is something that we need to look at. Mr. President, many of our children leave home to school but never reach, having been diverted by other activities. And under the Education Act, in spite of compulsory attendance records, it is apparent that no mechanism is triggered if a child does not attend school. It's something that we need to look at to ensure that our children are kept on a straight and narrow and don't find themselves in conflict with the law. And even a cursory look at Regulation 27.3 in the education regulations, Mr. President, allows for deregistration if a child is absent for 1 month without notification of withdrawal. Mr. President, to my mind, 3 days should never pass without a mechanism being triggered that engages other agencies to include the police, the CDA, Ministry of Social Security, Education, to determine what would have caused the absence of this child from school. You know, my experience in the political field, I see parents coming to me to say that, well, they are having a particular issue at school. And when you check on it, you call the school to find out, and you are given information to say, well, this child is no longer in our school because they never came to school for the particular period of time. So they are out of school. And you seek now to go through the ministry to see what assistance can be given to get these kids back in school. And you have, you get responses that don't facilitate the particular situation. That child remains at home. But nothing was triggered. Nothing caused anyone to go and find out why this child was missing after even the first week. But they were allowed to be out of school for 30 days, and then they are deregistered automatically and out of the school system. So, Mr. President, I read the comments, heard the comments of our Minister Reid with the reintroduction of the truancy officers. And I hope that that gets off the ground and that it works efficiently to seek to also capture situations where kids are out of school for a particular period and not cause them to be deregistered. So, President, the whole program of values and attitudes is something that we have to look at. We have to return to basics in order to prevent our kids from running in conflict with the law. Social and moral decline, Mr. President, is evident all around us. Mr. President, the former Prime Minister, and he spoke about it then, and I've seen comments that he has made, and I refer to the Honourable P.J. Pattison, who made the comments way back in 2004, I believe it was. 1994, sorry. 1994. Values and Attitude Program. And, you know, Mr. President, he has spoken about it again. My research took me to 2000, I believe, 14. And we are now in 2018. And it has been spoken about, a program that never got off the ground, for whatever reason. But I think that the whole concept of it, is something that we need to look at and deal with it and get it in place so that we can have the values that is required in our country. Mr. President, there are several comments that have been made. And I've heard in recent times, again, Minister Roel Reid has sought to revamp, reshape, and to get that program going. And I think he has started off on a good footing, because it is not going to be just persons from this administration, but he has involved his opposition counterpart to be a part of the whole reformation and implementation of this program. And I think that stands you well, Minister Reid, in moving this program forward. And all I can encourage is that it is done with alacrity. You have already done it with inclusiveness, but you do it with all the innovativeness that you can come up with. Mr. President, our dancehall artists, and I suspect that persons may say that I become controversial here again, but we must find a way to incorporate them within this entire program of which we speak. And Senator Webby is here. I don't eat, it's the flary or the fairy mackerel. The flary mackerel. I'm not a mackerel eater. But to be honest with you, when I saw the advertisement, it was really catchy. And you must be commended. Grace, yourself, must be commended for incorporating the dancehall in the marketing of your product. Must be commended. And I'm certain that if you probably check the record soon, you're going to find that the consumption of that particular item is up. But you know, Mr. President, I went on YouTube and I looked on two of our popular artists. And I would certainly believe that the amount of views that they got for some of the things that I saw on YouTube, which is supposed to represent music and creativeness. 10 million views. A lot of politicians would want to have their programs that they put up in social media, getting the amount of views that these dancehall artists get when they place their things on YouTube. You know? But, Mr. President, just to look on some of the words of some of these, what comes out of some of these artists' mouth, and which is accepted by young people. They can give it to you word for word, and they can't say the national pledge if you ask them to say it. They cannot repeat the national anthem of Jamaica, but they can give you word for word what is said by some of our dancehall artists. So they are popular. How do we incorporate them in dealing with what we are grappling with? Improving on values and attitudes and moving away from some of the content. And probably if they don't want to move there, we have to become more serious. It may be that we have to start looking at the whole issue of censorship. Some persons may not like that. Some persons may not like that. They may oppose it, they may criticize it. But Mr. President, when I hear, Mr. President, some words that says things like this. What them say? I am a lunatic. They don't know we have the most pneumatic. And I'm certain that his matic is referring to the automatic weapon. Me no have to go bad. Me no have to go bad up myself. Them know say me bad already. Them know me head mad already. Make them family sad already. Boy drop. And it goes on. It goes on. But you know, I will struggle with it. I will struggle with it. I will struggle with it. But you know, Mr. President, 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 you know, as a mobile man, you know, as a man from Montego Bay.
Senator Sinclair.
Yes, sir.
Senator Sinclair, Senator, are they accusing you of having problems with patois?
Mr. President, When I was going through the words of this, the lyrics, when I was going through the lyrics of this particular popular tune, which I said had 10 million views, the part that upset me the most is when he went on to say, Moby man lift up the rifle, them one locking. Watch him like mosquito and then clap him. Him gapping, later upon the news, can't watch him. What is it that our artists, with so much popularity, Mr. President, is seeking to convey to our kids?
Senator Brown is asking for a translation. Sorry, okay.
You know, and there's another one, but I won't detain us. But you understand where I'm going with the argument. Ask Senator Crawford. The video, as a matter of fact, you know, as a matter of fact, I won't mention his name. I won't mention his name. But there's a recent video that has been circulating yesterday. The recent video that is being circulated just this week. Look at it, and you will know who the artist is, because he was clapping a matic in the particular video. Yes. And so this is what is conveyed to our youngsters, with the glamour behind it. Mr. President, many of these artists glorify the gun, murder, evil, and gang activity. The very words of these songs, as I said, are repeated by our youngsters who don't even know the words of the Jamaica national anthem. Don't know it. And our youngsters are struggling to make the distinction between what is meant for entertainment and what is reality. They express themselves in the very same way the words of the music describes. So, Mr. President, as I say, it may get to the point where we have to take some serious and drastic action. Some countries have restricted access to YouTube for this very reason. I don't know if that is a direction in which Jamaica may want to go. It may not be. But we have to start thinking, how can we bring these persons on board in giving a good values and attitudes message that our kids can take on? Mr. President, and also in this entire program of values and attitudes, we must hold up to our nation the noble institutions and persons who have contributed to the significant improvement of this nation, whether they are on that side or on our side. Persons have made, at great sacrifice, significant contribution to the development of our nation. And you know, only in recent times, Mr. President, there was an effort there which has been completed to the renaming of a roadway from the north-south to the Edward Siaga Highway. And you know, Mr. Siaga, Mr. President, at great sacrifice, he gave up his American citizenship. He has contributed to the cultural, social, economic, and political landscape of Jamaica.
Point of order. That's a jacket.
Senator Scaffery, the Speaker's time has expired.
Okay.
Sorry.
The question is that the Speaker's time should be extended. Those in favor? Those against? The ayes have it.
You know, but what I'm saying, as I said, these are persons who have made a contribution. And when we do things that we do, and you seek to belittle, destroy, what is it that you are, what message are you sending to our children? That they must go out there and behave in the same way? The crass attitude when you
President,
went out.
point order, Mr. President.
State your point, Senator Scaffery.
I just want to know what clause the Senator is referring to when he brings that point. Because we're here to debate the child diversion bill.
That's not a point of order.
I think he has diverted way far from the bill.
Next time when I ask you, please take the point of order. That's not a point of order. Continue, Senator Sinclair.
So, Mr. President, what occurred on that particular day is not a good example. And if we allow our kids, to go down that path, then you are going to have the greater use of the Child Diversion Act. We must seek to hold up to our youngsters good values and attitudes so that they don't have to find themselves in conflict with the law. They can escape from crass behavior that they find themselves in, which can bring them in breach of
on
the
the point
law.
of clarification, Mr. President.
State the point, Senator.
Yeah, on the point. Is the member of the Senate saying that when the JLP staged a demonstration in Montego and blocked the road against Petro Carib, that they were sending a good example to Jamaica? You know, if you do it, don't complain when others do it.
Is that
Stick to bill, don't spoil the bill.
Senator Sinclair, continue, please.
But see, we are starting from, you know.
Senator Sinclair, please.
Where I started is that we need to set appropriate examples through different methods. We don't want our kids to find themselves in the formal system, where this, which Senator Sophia Bin spoke about, where she spoke about having to provide the adequate resources. Let us see if we can restrict or reduce the number of persons that find themselves in this formal system. And how do we do that? Build proper values and attitudes. And as leaders, let us not go down the particular road which you found yourself, because that in itself was childish. And we have to find that. Why are you going on like that, Skeffrey? I'm not quarreling. I'm speaking so that you can hear. So, Mr. President, I just placed...
Senator Sinclair, would you kindly address me and Senator Brown? If you have a point of order, please stand and sit. If not, please, thank you.
Mr. President, I place those issues on the table because we don't want for our youngsters to find themselves in conflict with the law that will then put burden on a system which, based on the question posed by Senator Fraser-Binns, raised the issue of resources and adequate resources. Let us keep them away from conflict with the law. Let us instill in them good behavior and attitude, and for them to uphold what is right and abide by the law. If it so pleases you, Mr. President, those are my comments.
Senator Reid.
Thank you very much, Mr. President.
Thank you, Senator Sinclair.
Huh?
Carry on.
I want to, President, thank the members for their robust engagement on this very important bill, and I'm happy Senator Fraser-Binns and, of course, my good friend Senator Crawford, and I'm sure Senator Floyd Morris would agree that this is something that is good for Jamaica, and it has straddled both administrations, and we agree we want to pass good legislation. So we welcome the robust debate, and certainly when we go to committee, we can look at any further amendments as necessary. Senator Crawford, however, in your submission, this particular legislation deals exclusively with children as defined in the bill, and children who otherwise would be subjected to action in the court, criminal action in the court. So the point is that we don't need to now change the name to deal with youth, because the courts will have the discretion, whether by the Child Care and Protection Act or by its own discretion, to deal with sanctions that they think are appropriate based on the circumstances. So I don't think we need to. But it is a particular issue, as you know, that deals with children, particularly between the ages of 12 and 18, who otherwise, if they were brought before the courts could incarcerate them, and we really don't want. And in fact, for many minor offenses, you know, Senator Fraser-Binns, I mean, you raised some of them in Schedule 2, but they're really for minor offenses, and certainly we shouldn't be incarcerating our children for those minor offenses. You talk about issue with sexual offenses and disorderly conduct and all that sort of thing. So there's no need for us to deal with the change in name of the legislation or focus. Senator Fraser-Binns, but the clarification you ask about the committees, yes, the overall national child diversion office will be staff, will full-time staff, but the parish would be part-time. So that is all. We can't have. Sorry. Yes. Well, as I said, they'll be part-time, and they will lean on the overall child diversion office for the additional support. We'll have to have a joined up government approach in this particular matter. We will take in committee the issue of the representation of parish committees on the National Oversight Committee. I take that as a point. We also will be looking at the point you made as to the definition of a child in conflict with the law to include those who actually are being convicted. So that is you're saying you're not supporting that. But that the technical people are saying they're not actually supporting that one, but we can. The issue with the consent of the victim, that is also something that that you raise in light of the very nature of the child diversion and the different issues to deal with the justice system approach. It's actually interwoven in the diversion process. Victim consent is crucial, and this very issue of whether victims' consent is necessary was raised in the law house. However, Clause 2, Section 5 is a safeguard, which is added to bring balance to a victim which may be without consent. So there's a balance. So that has been. Sorry? You're saying it's concealed. All right. Well, as I said, when we go to committee, we can look at that. 19, you mentioned the issue of the role of the constable. Clause 19.7 obliges that the constable be advised or advise the court of the child's failure to complete the program. In Clause 19, the court can take into account the, yeah. No, that you raise that as well. You asked about the role of the minister in setting order. No, that's 20. No, you're asking about the role of the constable, whether or not you have to go back to court. In other words, if the child has failed the child diversion program, do you have to go back to court? But I think I had mentioned already that in the clause, no, you have to refer back to the constable in the first instance. If it is the court who made a reference, you go back to court. But if the constable made the referral, then you have to report back to the constable. And the constable can make a determination to proffer a charge. You mean in terms of going back in the program? All right, well, we look back at that if you're now saying whether the clause is explicit that on the report of the failure of the program, whether or not the constable could determine whether the child can still be subjected to child diversion based on the circumstances. Although it was said in the prior clauses that but there are sanctions. It's not automatic. So there are sanctions also if you fail to complete the program or you commit offenses during the period of the child diversion program. There are some sanctions. But I believe we can. Yeah, he must notify the court. Right. So I think what they're arguing is the explicit statement, and I'm not sure that all of that necessarily is a language that you want to capture in that. But as I said, we can look further in committee because I'm just wrapping up, and we're not actually in committee. So I think perhaps what we should do is just close the debate then, and if there are any further consideration, there are regulations, by the way, to come. You had raised the issue of where should the informal warning be done and so on. And I think if it's, if it's informal, it's informal. Right. Just also want to say that in regards to the matter that you raised in terms of Section 24, the repealing of Section 24, that there is a current revision of the Child Care and Protection Act. So those issues can be dealt with there. We're not going to trouble it in this particular legislation. All right.
Thank you, Minister. So that the question is that the bill be read for a second time?
Mr. President, can I now ask that the bill be read a second time?
Thank you, Minister. The question is that the bill be read for a second time. Those in favor? Against? Ayes have it. Madam Clerk.
A bill entitled An Act to Facilitate the Implementation of Child Diversion in the Criminal Justice System and for Connected Matters, read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Thank you very much. There is an amendment sheet which I take it that everybody is in possession of. This is the same thing. This is the same thing. Both of these that you just gave me are the same. Thank you very much. So I'll take clause 1. Those in favor? I put clause 1. Those in favor? Against?
Chair, I made a point last week that I thought it should have been extended to youth diversion. The reason posited that judges already had a ability to use their own, what was it? Conscience is not the right word. Discretion. I don't believe is a satisfactory one. In fact, if that was the basis, then we don't need this one either, because judges also have the discretion with anybody in front of them. So we believe that the benefits of diversion can be extended to those under 30, under the thing called youth, as versus just 18.
Mr. Chairman.
So you want to respond, but I believe that there is a legal definition of child, which is what you're aiming for.
Mr.
Minister,
Chairman,
would you respond?
Last week, we did indicate to Senator Crawford that there is a definition, but I do get the point that he's trying to make, which is that within context, that he wants to see that adults are also receiving an opportunity. But there is an opportunity, Senator Crawford, through the Criminal Justice Reform Act, which speaks to the alternative mechanisms besides incarceration, which includes probation orders, suspended sentences, community service, and other things for adults. That is also to be coupled with the drug court treatment, which is also a diversion, which is afforded to adults. You would have heard Senator Sinclair speak about dispute resolution as well. So there are several things which may not be the exact same diversion, but which within context allow for an alternative mechanism to be considered in the mind of the deliberator, the judge at the time, when it comes on to the unique nature of whatever that case is that the adult may be in. The child diversion bill is very unique to children, particularly because it seeks to appreciate the unique nature of a juvenile offender as opposed to an adult offender.
No, it's a totally different concept. The options open to a court in relation to adults are options which arise after conviction. After conviction, a community service order is a form of sentencing. What I understand the senator to be saying, a community service order is probation that you mentioned. Probation comes after conviction. You can't put a person on probation before. Mediation is a part of the process, and the matter goes back to the court for the court to make a certain determination. This is not mediation. No, it's a different concept. Don't confuse them.
What we could say, though, is that from a policy perspective, senators, the Ministry of Justice considered creating a framework to address children, persons under 18 as defined by law, and child offenders as defined by the Act. Senator Fraser-Binns already earlier raised a concern about resources, etc., and how it is that the mechanism that is being put forward will even manage with that. So I think the policy position is quite clear that we're dealing with children under 18.
Minister, my intervention was to make very clear that the position articulated by Senator Crawford is quite different from the position which Senator Charles is explaining. The position of Senator Crawford is to deal with young children and young adults. 30 may be an age that we can't reach, but perhaps less. But what Senator Crawford, as I understand him, was saying is, look, if it is that we want to transform the behavioral patterns in the society, then there are persons who, after having reached age 18, they become connected with criminal activity, and therefore maybe the statute should go up to age 20, after which, you know, you're deemed to have a settled form of behavior which can only be treated in another way. But you want to divert. You want to divert. You want to transform behavioral patterns. So that is how I understand what he was saying. And I would support the position, even though what you have said, Minister, is that the policy is such that it will deal only with the child as defined. But policies are not cast in stone. And maybe if it is that we are to, you know, collectively try to bring about this transformation, then those with a particular responsibility could urge the policymakers to extend, and the extension would not disturb the provisions, because it would only be an extension of the definition, one definition. So I don't know if you need to be adamant that...
Thank you, Senator Knight. As I understand the position, the Minister is saying that issue of the age to which the legislation would apply relates to the statutory definition of a child, and that's a policy issue. So I'm going to put... Thank you, Senator
Before you put it, sir.
Yeah, but I can't direct government policy, but I'd like just to explain why I'm making a suggestion. Please, just allow me to just explain. I'm just trying to contribute. If my contribution is welcome, you can resist it. But let me try and contribute. The Child Diversion Act actually indicate that not all offenses are considered, that some offenses are considered. Offenses in particular were defined as minor offenses. There are countries that don't have an age limit. On your first offense for minor offenses, they seek not to have you incarcerated or go through this process. We have seen in this nation, for example, a married dean that went to jail for a spliff, and he came out dead. But we have also heard on many occasions of the ability for prison to make you a more hardened criminal than what you went in for. So you go in for a minor offense, and just for protection and safety, you come out as a member of a gang. All I'm saying here is that by definition, and you made my point, you said the definition of a child is under 18, which means an 18-year-old don't qualify. And I made the point in the presentation last week that the benefits of diversion don't have an age limit. the benefit of rehabilitation, the benefit of less cost to the system, the benefit of non-recidivism don't have an age? Yes. So if it is that the ministry would consider a change from child to youth, it would have captured more persons and extended the intent of the policy.
Mr. Senator, your minister says that she's not changing it. It's a policy issue.
With respect, it's not a matter just for the minister, you know. It's not a matter just for the minister. And the minister, quite frankly, is not here. So that there ought to be some consultation or something like that. I don't want us to just ignore a young senator's
no, but with respect, Senator Knight, if I may,
considered
if I may,
approach.
It is
and you
certainly
know
not being ignored.
We considered it, and what we are saying, Senator, is that, as Senator Charles has said, under the justice reform, the consideration of a diversion for persons outside of the defined or the definition of a child can be taken up. That's what I'm saying. So it's not a dead issue. It's warrant or considering, but I'm saying it can be dealt with in a separate legislation. That's all. That's respectfully. That's what you're saying.
Thank you very much. So I put Claude.
President, Chairman, there's a definition which I have concern. Under child offender. No, we're not.
No, man, we
I thought we were going to
are
clause 2, sorry.
So I'm going to put clause 1. Those in favor? Against? The ayes have it. No. Clause 2. Senator Brown, the definition section. You were saying something?
Yes, I am. President, under child offender, on page 2, it says a child who is suspected of. Then it has accused, which means there's some evidence. They're charged, some evidence. Convicted, some evidence. But suspicion is so broad. And if you connect to conflict with the law on page 3, it speaks on suspicion. If you go to clause, and I'm just trying to make the link. If you go to clause 9.1, unless it speaks to suspected to have committed. But when you go to clause 21 on page 22, it speaks to reasonable suspects. And I believe that...
What clause in 21 and 22?
Sorry?
Clause 21 and 22 or page?
21, I just pointed that you use reasonable suspect.
It's clause 21 or page 21.
Oh, sorry. Clause 21 on page 22, where the term reasonable suspect is used. And I believe in the definition clause, where a suspect...
Mr. Brown, this is where you said 21 is not reasonable suspect, you know. It's not a reasonable suspect.
It says...
It's where an officer...
Reasonable suspects.
Or reasonably suspect.
Suspects, that's the same point I'm making. Reasonable suspects. In other words, suspicion in child offender is general, and it doesn't have the benefit of the qualification of reasonable. And I'm suggesting that where suspicion, suspected, is in child offender and in conflict with the law, those are under clause 2, that it should that there should be a qualification of reasonable. Otherwise, anybody can suspect whether it's reasonable or not.
Senator Brown, is under the definition of child offender, where you're seeing it in clause A, is suspected of, accused of, charged or convicted of a diversion offense and accepts responsibility for a diversion offense. So the child, my understanding now, I mean, and I am open to another interpretation. The child in this case, whether suspected, accused, or charged, would have accepted responsibility. So I understand where you're going, but I think that this would absolve your concern.
Yeah, that don't absolve my concern, because it is well known that anybody can suspect him, but there is a requirement that the suspicion must be reasonable. And that is why if it's reasonably suspect, and then you can bring in your and accepts, right? But if you look at the others that follow, accused require.
So you want
more
to
than
say a child who is reasonably suspected of,
accused of, charged or convicted of. That's all I want to.
The reason why the word reasonable is connected to the suspicion is because it is expected that in the context within 21, that constable would be considering things in a particular judicious way. But within the context of the definition of a child offender, right, there's no need to have reasonable there, because it is not speaking of the intimation of what that person is going through in their mind, in my view, right, at that particular case. Particularly because it is conjoined to the word and. It is saying and as well. So it's not just one person who's off on a frolic of their own asking a question. The child would have accepted responsibility. Again, I'm open to another interpretation.
My concern is that we're in this society, and coming from the history where we had the numerous vagrancy laws and so forth, which that black people, poor people, get drawn in easily. I want the qualification of reasonableness.
You will never hear me.
So let me finish, please. A reasonableness to be associated with suspicion or suspect.
What is more reasonable than the person who is being suspecting having to accept responsibility and say they accept it? And what could be more reasonable than if somebody says that, are you suspected? I say, yes, I am. I mean...
No, you know what is reasonable?
You won't hear me.
Because that child is such a mind that could be...
I have no difficulty with where you're going, because I understand and appreciate that what you're speaking of is protecting the integrity of a process. But sometimes you conflate legislation when you put in words where they are not necessary at that point. And to my view, in this case, where you have these two, section A1 and 2 joined, it is not necessary. It does nothing to support what we're both agreeing.
Does it do harm?
Perhaps not. And it's a matter for everyone.
I don't know if it does any harm, but my concern is that too often the words, you giving somebody the power of suspecting. What is worse? You talk about children here. And this child, police say, I suspect you have to do instance, and the person says, yes, I accept. No, we need to protect the children, and we need to make sure that the suspicion is reasonable. Because a child might very well say, yes, because afraid of being locked up or something. Put it there to protect the child. That's what I'm asking.
Problem with putting in reasonable there, though, because I agree with Senator Charles, is immediately after suspicion, there is the word accuse. So a child who is accused of. Now, an accusation, if we're going to leave accused, somebody like, I know that you can be accused of something and there's absolutely no reasonable basis at all. No, if somebody accuses you of something. So I believe if you put reasonable suspect and you leave accused, where an accusation can be made, be wild and so on, I don't think you'll be curing anything. But I feel comforted by the second part of the definition that says, and accepts responsibility, etc., etc. So that's what I would say.
So is there any intention to, okay, so Senator Brown, there is apparently no intention to change it. Would you like to make a proposal for an amendment?
No, I don't see it. Okay, sorry. Mr. Chair? There's an amendment sheet, Mr. President, clause 2.
No, I was speaking about Senator Brown with respect to the inclusion of the word reasonable, because if he wishes and he's not satisfied with the explanation, he can...
I just need some clarity, Mr. Chair. Given the fact that you are saying suspected and accused are general terms, which sometimes you cannot qualify, then why we put those two terms there to limit the child? What do we need to correct there to have them there? So why you don't start with charge and then you can send a child to the diversion program. Because these two, yeah, but there are different segments where along the spectrum, you don't know exactly where to have. So I would recommend that we delete them then. Because how do you measure them?
If I may.
So I seek some clarification.
Minister, if you're going to address Senator Skeffrey, do it on the mic, please. Do it on the record.
No, just saying that you would eliminate, you'd create a gap for more children to not have the opportunity to go through the process. What we're trying to do is allow as many children in the spectrum of steps that can be taken in child diversion, where they have accepted responsibility, but you want them to avoid going a criminal procedure path. So we'll take these lighter stages into charging, and the presumption is that where it's exercised, there's a principle of law that says that it will be exercised reasonably. So we wouldn't put in the language there because it's not necessary. It's how the law operates.
Like that. Total. No.
Senator.
Why are you confusing all this?
Yes, sir. The explanation given of the use of "and" suggests that it is the acceptance of responsibility that is the fundamental, the determining factor, the accepting. No. I'm saying, whether it's accused or whatever, if the child accepts, that is the fundamental. So if therefore that is so, it seems to me that A1 is insignificant. Because whether it is an accusation, a conviction, whatever, the fundamental, the trigger action is the child's acceptance. So if the child accepts responsibility for a diversion offense, whether it was based on an accusation or it was based on a suspicion, it is secondary. It is that he accepts. Therefore, it don't matter what it was the basis of his initiation. He accepted. Of what?
I don't want to go back and forth on it, but the reality is I appreciate genuinely what Senator Brown is saying in trying to protect against integrity of what is historically opportunities for persons to breach human rights. This is a definition section of a legislation. It's not even this section or a clause in the legislation. It is a... Hold on, man. We're not fighting, We're not fighting. We're at committee still. We're not fighting.
President.
So if I could...
Chairman.
Senator Knight, soon. 1 second. Soon finish. In my view, Senator Crawford, you cannot just place the definition A2 alone in isolation of context within which somebody who is utilizing that definition, they would have to understand the context, which would, the nexus, what would be the reason why a child would be accepting responsibility. And that is what I'm saying. You have to lay out. Otherwise, you broaden it too far. What the legislation is seeking to do is not to put, it cannot cure everything. Can't cure everything, but the legislation, the framework of legislation is to provide a guideline for operation. No, if they don't accept in this regard, in my personal view, the two are conjoined unless it changes.
Chair. Sir.
Senator Knight wanted to make a contribution. Thank you very much. Go ahead, Senator Knight.
Chairman, personally, I would go with either. But I well understand why it is that they are arguing for this. And quite frankly, if the definition happened to be child offender means, as applicable, a child who is reasonably suspected or accused of with reasonable governing both the suspicion and the accusation. I don't see where any violence would be done to the intent of the statute. And I see where clarification would be brought to it. And I think Senator Braham had mentioned the aspect of accused, so that if reasonable governs both suspicion and accusation, we don't have a difficulty. Because the child, for example, has to consent in the presence of an adult who may very well say, but listen, this suspicion here, it's not reasonable. It's not reasonable. And why shouldn't an adult have the right to so opine? So what violence could possibly be done by adding reasonably? And then what I find difficult is that a child who is convicted of a diversion offense, then that child now has to accept responsibility? Why? Why is that necessary? If they have gone through the process. No, but then if he says, no, I didn't do it, then there is an appellate process.
The clause are conjoined with 4. That's what I'm saying. If you look at the definition under 2, accept responsibility, and then go under 4, clause 4, it qualifies. And at the same point you're making, that the child is not accepting responsibility without the presence of a parent or guardian. I think that is a fair balance overall, in my view, without necessarily inserting the qualification, reasonable suspicion, because it's to the extent of the application that the child is guided anyway to, the same 4, right, in the same clause, subsection 4 of this said clause 2, and it asks for us to interpret it within the subsection 4. So when you're applying this clause, you have to apply it under the definition of what it means of the acceptance of responsibility.
All this does is to say that a child, by him or herself, cannot accept responsibility. That's all it says. I'm not going to fight to the last drop of my blood on it, but I don't think you should hold out to your last breath.
Mr. Reid, you want to just take, the question is the inclusion of the word reasonable. I understand your point. I understand what Senator Knight and Senator Crawford and Senator Brown are saying. You want to just take some instructions further and then we can move on, because we are...
We'll do. We'll come back to it.
Mr. Chairman, while we're still at clause 2, Senator Reid, I had made a recommendation in terms of the definition of conflict with the law. That's on page 3.
Yes, correct. You had, in fact, raised the issue, Mr. President, the concern about the definition of conflict with the law. My advice is that the definition of conflict with the law takes in consideration the difficult stages the child will be placed within the criminal justice system. Once the child is convicted, however, and is sentenced, which sentence may be suspended, that child no longer is in conflict with the law. So, so this is why it's defined like this.
So, am I to understand, Minister, that you're being advised that the definition of conflict in the law operates so that it ends at the point of conviction?
Yeah,
so once someone has been convicted, that person is no longer deemed to be in conflict with the law?
You're no longer in conflict with the law.
So what are they in?
No, but
I just want to know.
But you have been sentenced already, so you're not in conflict anymore.
Convicted don't mean sentenced. So I'm just trying to understand.
Once sentenced.
Yes.
Right? And I'm clarifying. I appreciate that.
It's convicted and sentenced. So go ahead. The point is noted. It will be convicted and sentenced. You're no longer in conflict with the law.
The definition of child offender. But I'm not understanding, so I'm seeking further clarification from you. That is it that once a child has been convicted, that person is no longer deemed to be in conflict with the law, and as such does not fall within this definition?
Well, my reading of the legislation as currently constructed is that, remember now, you could refer a child, or the constable refer the child to the diversion committee for a diversion program, or the child will go through the regular criminal justice system and be convicted, but the court would refer the child to a child diversion program. But in other words, if the court were to have sentenced you to a penal system, barring parole, etc., it's not envisioning that you would apply the same treatment in that regard.
And that is where you're wrong, because the very amendment to the Act, for example, the Parole Act, allows for that consideration to be made. But I'm not even there yet in terms of sentencing. I just want to understand whether, for the purpose of this Act, if a convicted person is deemed to be in conflict with the law. If your advice is that it is not, then it is what you're advised. I just want to know.
I beg your pardon, Minister? No, you can take instructions in about it. No problem. You want to just deal with the question of the reasonableness so we can move on. I don't want to really come back to it. Just inquire concerning.
All right, Mr. President, we're not accepting the amendment to the insertion of reasonableness, since the explanation is that suspicion, being suspected of something, is real, is not something that is imaginative. So we're not accepting any amendment.
About the clarification with conflict with the law.
I'm still waiting on that advice.
Okay. So can we go to clause 3? So,
Yes.
So you'll ask for the recommittal of clause 2 today?
Yeah, recommittal clause 2, because there are no amendments we have.
Can you look at clause 3, please?
7.
Can I put clause 3? Those in favor?
No, sir. I have something. Sofa. This hour. Clause what is?
Well, Senator Scott Motley, the proposal is 4 to 7. Is there any difficulty with that?
I have a thing at 6. I'll raise.
You have something at 6?
Yeah, just.
Let me just, as out of an abundance of caution, let me take clause 4. Those in favor? Against? Ayes have it. Clause 5. Those in favor? Against? Ayes have it. Clause 6. Senator Brown?
6. John, it goes to parish committees. My one preference would be, instead of finding 117 people to serve, that's what the parish committees require. 9 people under the schedule for a committee. I'm in two minds. One, if you're going parish, maybe you want to look at adding Portmore as a municipality with much more population than some of the parishes. But I want to recommend to you that you really should be considering county committees rather than parish committees. And then when you come to review, if it warrant, because the number of cases may not warrant establishing specific parish committee all over the place, and you may be better served by going with county committees, right? Because you require 117 people to serve on these committees now.
Parish committees, you're likely to have speedier attention than if you have a county, Mr. President. So I suppose that there is advantages on both sides.
No doubt that is something that can be monitored.
Absolutely, and reviewed later on in the bill. We take the clause.
Thank you, Senator Brown, anyway. So I put clause 6. Those in favor? Against? Ayes have it. Clause 7. Those in favor?
Mr. Chairman, I had mentioned regarding the National Diversion Oversight Committee that there should have a representative, that there should be a representative from each parish committee on this national body. Of course, it means that you may have to amend the number of members, but I think it is critical that that consideration be made. Clause 7, I, 1I,